you have the handover certificate, page 2. It says financial settlement status. It confirms that all the payments were received, save for a deduction of 7% for failure shortcomings that are acknowledged by the statement of the contractor who wants to rectify them. And then investor statement at the bottom shows that there were problems with the contractor, and moreover, the contractor was going over budget. So that was the reality on the ground. And in any event, all this does not matter. Why? Because Rosmin informed Slovak Republic of the problems. The Slovak Republic didn't raise any objections, and later we see granted a further authorization to my client to resume works. And I'll walk you through those documents. Tab 20, C221, October 15th, 2001, Rosmin informed the DMO of the suspension of the mining activities because Rosmin stopped works and refused, more importantly, to withdraw from the works. Tab 21, November 30th, 2001, Rosmin notified the DMO of the suspension of the mining activities for a period exceeding 30 days, in accordance with Decree 1998-89, dated May 20th, 1988. That's tab 21, Exhibit C26. What happened thereafter? Rosmin engaged in extensive negotiations with its troublemaker, shareholder, and contractor, Rosmin Morin. A settlement agreement was reached. It is at tab 22, R130. This allowed the handover certificate that I previously mentioned, dated October 23rd, 2002. Then what happened? Tab 23, if you turn to tab 23, we, in the meantime, applied to obtain authorization to resume the works in anticipation that this was being settled. Next tab, tab 24, it's Exhibit C223, the mining office rejected our application, not by saying it's too late, but it's simply saying you didn't provide the required documents. And again, post facto, one of the post facto defenses of respondent in this arbitration is that, oh, we weren't generally slow, incompetent, we didn't know how to file documents. But it's the government bureaucrats that are, instead of learning and avoiding corrupt practices of how to ask for documents and identify them, that are incompetent and causing the delay. And again, this is not our submission, but if you turn to the next submission, tab 25, we appealed the decision of the MMO, and the courts, the main mining office, recognized that it was nonsense why our application was denied, simply because the documents that were expected by the DMO were not even clearly identified for us to be able to follow up on that request. Tab 26C27, and if you had to identify identify the material documents you need, I would say I would start with this one. It's among the top, or the only 10 you would need for your decision making. It is tab 26, C27. What is it? It is when the DMO ultimately issued to Rosmin the new authorization on mining activities. And if you look at the date, it was tab 26. And keep that handy because I would be referring to that. On the second page, tab 26, it was valid until November 13th, 2006. What did Rosman do at the time? It prepared all administrative permits, authorizations necessary to initiate in June 2004 a new tender. All of the permits, the local authorizations are cited and documented in the record. I will not walk you through them. A new tender was organized, and who won? It's a company called Siderit. You have it at tab 27 that won the works, previously granted to Mr. Courage for an amount of $2.5 million US. That is tab 27, C259. To show how diligently we were proceeding at the time and how eager we were to move forward, you have to turn to tab 28, and you would see that pending this tender and finalization of the contract work, by specific work orders, we allowed Siderit to carry out preparatory works towards the completion of the above grounds structure as of October 2004. You have exhibit C254, C254, 255, 256, 257. Then, if you turn to tab 29, you have the witness statement of Mr. Agiagos and Mr. Rosloznik. What do they say? Is that they confirmed that on October 14th, 2004, so this is Mr. Agiagos that disappeared. You know, he's no longer with Belmont. Belmont is no longer involved, and we'll get to this point. He's on the ground following diligently what is going on, and meets Mr. Baffy to announce to the DMO that they will be, Rosman, proceeding, resuming with the works. And Mr. Baffy, there are two witness statements. Mr. Baffy, the respondent didn't deny that that meeting occurred, and Mr. Baffy obviously absent in front of the evidence on the record, and notably what he did in the following months. On November 8, 2004, in any event, if you turn to tab 30, exhibit C267, you have a letter from Rosman to the district mining office dated November 8, 2004. This is the second this letter that I would like you to keep in mind. Remember, I said there are 10 maybe exhibits that are material. This is tab 30, exhibit C267. The first one was obviously tab 27, C27. Rosman officially announced to the DMO that it would resume mining activities by November 18th, 2004. What did DMO do? It carried an inspection to verify the works. It was obviously informed that Rosman could proceed with the works because there was a mining authorization, the first document that I asked you to keep as a material document, the authorization of May 31st, 2004, and carried out an inspection. And could you kindly turn to that inspection? It's at tab, it should be 31, I believe. And it's the third of the 10 documents that I like you to keep in mind. C28. What does it say? It starts with the first three paragraphs to remind the background on what ground the works are being carried out. And it refers to the first document I said is important, the November 13th, 2006 authorization. It confirmed the background. It's Mr. Baffy, same one that Mr. Agiagos met a few weeks before. The inspection lasted significant hours, and at the end, during today's inspection, no facts were discovered indicating breach of legal regulation in force. So he confirms, by cross-reference to what is undisputable, is that we are entitled, based on the May 31st, 2004 authorization to proceed, and we have until November 13th. And he comes to see the works, and he finds nothing. Now, we would say to yourself, all good. Finally, we're moving. We have gotten rid of this troublemaker, Mr. Koresh. We have all these reports that could confirm the prospects of this talc deposit. We have the means that are identified. We have all the permits. We have a new contractor. We have also the authorization. The works have started. Mr. Baffy has even come from the mining office to confirm, and he confirms. But that's not counting with the reality, that noble sovereign state, taxpayers' money, the corrupt practices that I mentioned. We don't need that. We don't need to establish, we don't want to establish corrupt practices, just for the ambiance. Look, the facts speak for themselves. Tab 26. Tab 34, I apologize. It's tab 32. Further apologies, tab 32. Tab 32, Exhibit C30. 3 weeks later, that's the fourth document you need to have to keep on the record. The DMO, under the signature of the same Mr. Baffy that had reference to the 2004 valid under 2006 authorization that confirmed the works on the ground later, writes to us to revoke our rights. It does so by relying on a law that you find at tab 34, which is which you find at tab 33, I apologize, which is an amendment of 2002 that they apply the mining office retroactively to apply to a mining investment that started in the early 2000s. Turning a blind eye on tab 26 and tab 31, the May 31st, 2004 authorization confirmed by the site visit that referred thereto and confirmed by the quality of the works. So application retroactive of the law and violation inconsistency with not only the site visit but the authorization. Worst, if you go now to the next tab, tab 34, C29, you see that before the revocation was notified to us on January 3rd, 2005, the government had put it on tender. All right, I mean, it sounds incredible, but that's the damning evidence. December 30th, 2004, they tendered our rights. They tendered our rights. So if they tender it on December 30th, that means necessarily that the decision was even taken weeks or months prior to that. Then, chronology, who won? As if all this was not funny and damning enough. Who won? A company by the name, if you go to tab 35, C31, Economic Agency. Who has heard of Economic Agency? Remember the post facto defenses? You need financing. These guys were, they gave it to Economy Agency. Economy Agency. Have you heard of Economy Agency? You've done mining projects, mining disputes. Well, and let's look at the other names before we go to to see who is economic agency. Mondo Minerals, worldwide leader, MII, they rank 4th and 6th. Next tab is complaint of Mondo. And a reminder in the following pages, C268, who the economy agency is. It's a shell company owned by an accountant who's the wife of Mr. Korech, the bidder, shareholder, and contractor. What did we do? We decided to litigate our revocation. Yes, Belmont notified. If you look at the notice in 2005, we said we would go to local courts eventually, and that's what we did. February 27th, 2008, and we are right, because not everybody is corrupt. Not every organ is corrupt. In fact, hopefully with your decision, it will have an impact for that all the organs are not corrupt. Tab 37C33, decision of the Supreme Court that says violation of due process. I will go back to that decision. Tab 38C34, what happened? DMO acted as if that decision did not exist, the decision of the Supreme Court. Why? We know why. And confirmed the rights to economic agency, which in the meantime had been absorbed by VSK mining. We were in the hamster wheel. Okay, what do? Let's go again. Let's try to resolve this. Let's try to resolve this. And we were right. Because the Supreme Court, if you turn to C36, tab 39, told us we were right, this time on substantive grounds. We'll revert to that. They said everything that I just told you. Retroactive, it doesn't work. There was an authorization, everything, nothing made sense in that. What had happened in the meantime is that EuroGas had dispatched under the BIT, we had as Belmont, but so did EuroGas. I remember we dispatched, I wouldn't say a notice of BIT, because we said we were going in 2005, possibly to local courts, as we did. But EuroGas dispatched, if you look at tabs 40 and 41, R7 and C31, a BIT notices on December 2010 and October 2011 as a 33% shareholder, as a 33% shareholder. I mean, had they truly believed that they were 100% shareholder, the US company or someone would have raised that claim. But that Austrian company gave notice for a 33% without mentioning any of its group's right to any additional shareholding. If you turn to C42, you have the response of the Slovak Republic. It's May 2, 2012. It's well after the permissible date to bring a BIT claim under the Canadian-Slovak Treaty. What does the government says? As already outlined in my letters of my predecessors dated June 16, 2011, February 9, 2012, the administrative procedure before the Slovak Mining Office is still pending. Therefore, any discussions regarding the alleged claims of EuroGas seems to be premature prior relevant decisions of local authorities are rendered. What happened next, tab 43, C37, is the DMO again reassigned to VSK Mining. We appealed the decision. We didn't let go. Tried still to make it work out. Tab 45, C273. And the MMO on August 2012 confirmed the DMO's office. And that's when we decided to get out of that hamster wheel and the engrenage. This is the damning chronology for respondent. I submit to you that it's hardly possible to get a better case on international law. It is a textbook mess that is impossible to clean for the Slovak Republic. It is a textbook case for three independent reasons. One, obviously, the taking was not procedurally correct, which is a standalone ground for liability under international law for expropriation, said expressly in the treaty. The expropriation has to be according to due process. No opportunity to be heard, no advance notice. Worst, it was notified, when we were notified, the decision had been taken in the publication of the tender. And you have somebody that already did the groundwork for you, Mr. President, is the Slovak Supreme Court, C-33, tab 37, decision of February 27, 2008. It confirmed what we are all saying, is that there was no right of defense and violated the right to be heard, the right to express an opinion, to propose evidence, to be acquainted with the reasons of the Administrative Act. Everything is set. Then also, it's a textbook case because it's a violation of substantive reasons. The 2002 amendment cannot apply retroactively to ongoing investment that started before that. The chronology is damning again on substance because you have an authorization of May to 2016, 2006. You have confirmation of the works that were ongoing. And you have a Supreme Court decision on the same, at tab 39, that says exactly what we said and adds, in fact, that even if the 2002 amendment applied, it's not automatic. You need to look as whether the intention of the contractor, the investor, is really to invest or speculate, because the 2002 amendment was against to stop speculation. And here, the evidence is clear that we were a diligent contractor. We had contracted prior to the award of contract by orders. They were starting to work. Then we were obtaining the permits. The work started to the satisfaction. So even that would not stand. Finally, there is no compensation. There is no compensation. That itself is an independent ground for liability. What can we add? I don't need to address I already did the post facto defenses, that we didn't have the means because it's post facto, it's irrelevant, and it's wrong because we were proceeding. The fact that we were late in the licenses, in obtaining the permits, that's also superseded by the decision of May that granted us the mining rights till 2006. Also, the reason we had delays, we saw, because it was the mining office that couldn't identify the documents it was requiring. Now, what do we have? As I mentioned, we have aggravating factors. We have very aggravating factors. On its face, if you look at the chronology, you would see that when there's an authorization to proceed, given by the same authority, the investor proceeds, the works are confirmed, the contract is signed, and then the rights are taken by that authority without proper due process, with publication of the tender, then awarded to who? A nobody. An account owned by a company, shell company by accountant. Oh, that doesn't smell good. This doesn't smell good. Worst, if you now look at tab 45, you have your document production order. You ordered production of documents pertaining to exchanges between Mr. Courage Economic Agency or any of the 6 bidding entities on the one hand, and any Slovak body or authority on the other hand, before the revocation of Rosemin's mining rights or thereafter, but before the award of mining rights. Nothing was produced. This is bad. It is very ugly. And if things got worse, because if you look now at tab 46, exhibits C356, C357, and C358, you would see, as my daughter said this morning when I changed the diapers of my little boy, she said, oh, phew, it smells. And it smells bad. It smells big time bad. And this is not the poor baby's excrement. It is public money. It's the right of investors. It's the taxpayers' money, EU taxpayers' money, local taxpayers' money. It's the interest of mining activity. What is there out there? You would see that before the publication, before the revocation, while the works were ongoing, Mr. Mondo was in contact with Mr. Courage to forward the letter to the Deputy Minister of the Slovak Republic and the Minister, Mr. Roska, Minister of Economy at the time. These documents we underwent the burden to obtain after the document production was left unanswered. C057, another document, this time directly from Mondo to the DMO before our rights were revoked in December 2004. And finally, again, correspondence with the DMO, this time in February 2005 during the tender process. The other documents you precluded us from providing, I don't know what is your reasoning, President Maya. I don't understand it. I challenge it. I don't think it's good. I think you should reconsider it unless you really don't need it. It is documents responding to your document production order. I mean, it's very, forget about this document. When you see that they snatched our document, they have all of our documents. And we were obliged to beg. And then when we beg, they don't give, you ordered them, they don't give. That's why we managed to produce the documents at tab 46. And by the way, you get emotional when you find those documents. But I say to myself, to my client, why do you get emotional? After all, it's your order. If you don't get emotional, members of the tribunal, why would I get emotional? And then they don't respond. The other one, we cited, we have it. Just the person that gave it to us said, don't disclose it. We put it in our brief, and we described it in our brief. We described it, and I refer you to the description. It shows that during the tender process, the government, before even the mining tender committee were in place, were in contact with one of the tender participants, giving them comments on the other bidders, how it's perceived. Now, what happened then? Tab 50, we filed a notice of dispute on December 23rd, 2013, and then you have all the correspondence we flagged. They told us there is no, give us documentation about compensation. So even then they were not saying no in terms, they were saying we're in discussions on compensation, no longer specific performance, but compensation. And all they were asking is give us quantum, give us your substantiation before they prepare the criminal proceeding. So that's the case on the merits. It's bulletproof. I can hardly see how we can get a stronger case. You have everything, due process, merits, failure to compensate, corrupt practices, dissimulation of information. So what does one do in these circumstances? Either the bands gives compensation, or it does what Slovak Republic decided to do, is to take us for a ride during the treaty negotiations, to prepare criminal proceedings to get undue advantage and get our documents. And then, when it has those documents and the tribunal is constituted and cannot go on the criminal front, it raises jurisdictional objections. I will raise now the jurisdictional objections. If you allow me, you proposed. If the offer still stands, I could use a 5-minute break.
10.
Even better.
We resume?
Yes, we will resume if respondent is ready. Yes, thank you. I will be using mostly the second binder, but for some time at the beginning, if you could have the first binder handy, I would appreciate it. If you allow me, I will now resume by addressing the two jurisdictional objections that are raised against my client, Belmont. The first one is that we lack standing, and the other one is the ratio temporis challenge. If you allow me, I will start with the ratio temporis challenge. In general, before I start, I think I had hoped not to hear statements such as, oh, they did not submit a rebuttal expert report, expert statement. That shows that they could not find anyone that would submit a rebuttal statement. I mean, that is grotesque. I mean, the reality is that when we don't believe, to have to bring an expert on a point presented by the other side is that the expert report is not worthy, or the documents on the record are sufficient. So this suggestion, for example, by my learned colleague that, oh, nobody in Canada would want to support the position is extraordinary. And I wanted to make that clear, that it's not a sign of weakness, but rather of the fact that those expert reports are extremely weak, are not even worth addressing for the reasons I will explain. Now, rationale temporis, the Canada-Slovak BIT, it's at tab 2053, clearly says that excludes from its rationale temporis scope the disputes that have arisen more than 3 years before its entry into force. The BIT entered into force on March 19th, 2012. That means you can hear only disputes from March 19th, 2009 onwards. Now, respondent relies on these terms to allege that we are barred from bringing this arbitration as the dispute arose at the time of the revocation of our rights back in 2005, and puts forward a number of theories, says that that's the real cause, and a few others. As a preliminary matter, I wanted to point out the respondent argues everything in its contrary. If we go back to tab 40, tab 43, C40, it's tab 42, I apologize, tab 42. It's the letter which you're familiar with already, C40, May 2nd, 2012. May 2nd, 2012, well, the gentleman, its author, is the person in charge of the file, and responds saying it's premature because the relevant decisions of the local authorities are rendered. So prior to that, it's premature. So it means premature. It's not only about compensation, because if the mining authority is granted to us, it's over. And if they don't grant it to us, there is still, in fact, a question of compensation. But here they're writing to us. So then they say it's premature, and now we start the arbitration. We wait, and they say, and they wrote not only once, but 3 times, June 16th, 12th, and and on May 12th, 2012. So 3 times to say it's premature. So even on the face of that letter, if you take it, you would see that there's a common agreement that it was premature and we had to wait for the prior decisions of the court. And if you now go to the second binder, tab 51D. 51D, you would have to start from the back. It's the second to the last. We apologize for the confusion. On this tab, there is a large number of documents. So it's 51. It's 51, not 52. The second from the last. It should be 51E. E. So here, in the provisional measures, respondent says, every time that Rosman exhausted its right to appeal, its challenge succeeded, and when it did not exhaust its right of appeal, it voluntarily relinquished any claim it may have before an international tribunal. So here, they're saying, during the process, they said it's premature. We waited many times. Then in this arbitration, they say it's too late. And on the substance, they're saying go home because it's too early. You should have gone to the Supreme Court. I mean, does that make sense? Is that in good faith? Then they realize the mess. Then they try to split. They say, oh, for denial of justice, it's too late. So they argue everything, and it's contrary. The only consistency with the argument is the lack of good faith. And if you turn to the next page where we're talking about fairness, is the legislative history between in relation to this clause. This is a letter from Canada to Hungary. And you see the Hungarian official forwarded to many EU members, including Ms. Holikova, present in the room, from the Slovak Republic, about the intention behind these clauses that were inserted. You have the intention at page 7. It says to prevent undue unfairness to investors' disputes that have arisen, so disputes that have not arisen. It's unfairness. So I submit with Ms. Holikova in the room, is that Slovak Republic's conduct is everything but within the spirit of that agreement. It just uses every single defense with utmost bad faith and inconsistently when it suits it. In any event, all this does not matter because the case is quite clear on this point. Why? Because the language of the BIT is very different to the specific restrictions in terms of rationale temporis scope inserted by both Canada and Slovakia in many of their other BITs. If you turn to tab 52A, you have the agreement, the draft between the Slovak Republic and the Islamic Republic of Iran. And if you flip and you look at Article 2 of it, Article 2, 3, if you continue, Article 2.3 says this agreement does not bind either contracting party in relation to any of the fact that took place, to any act or fact that took place, or any situation that ceased to exist before the date of entry into force of this agreement. Now, if you look at the next tab, this is in reference to our memorial at paragraph 209. We summarize, and it's in footnote 205, the language contained in other Canadian model bits. This is the one I read you was Slovakia, this is Canada, and the footnote contains the reference. The document's now on the record. I spare a copy to spare you of having to put a copy of these agreements in front of you. And the language of those treaties says disputing investor may submit a claim to arbitration only if not more than 3 years have elapsed from the date on which the investor first acquired or should have first acquired knowledge of the alleged breach and knowledge that the investor has incurred loss or damage thereby. So what does that say? It means that if the sovereign states wish to have a restrictive position, which is consistent with the position, in fact, that respondent adapts in its defense in this case, they could have provided so. They know how to do so, as proven by the practices of both countries. Yet the drafters use the term dispute, which has a clear meaning under international law. There is abundant case law that shows unanimously, I must submit, based on when the same language of the clause is applied, that it means what we say it means and not what respondent alleges. If I had to cite just one or two, I would propose to cite the one Maffezini, perhaps. Maybe, yes, we can go to Maffezini, which is at 51, should be at 51B. At paragraph 96, it says, the tribunal notes in this respect that there tends to be a natural sequence of events that leads to a dispute. It begins with the expression of a disagreement and the statement of difference of views. In time, these events acquire a precise legal meaning through the formulation of legal claims, their discussion and eventual rejection or lack of response by the other party. The conflict of legal views and interests will only be present in the latter stage, even though the underlying facts predate them. And then it goes on with other relevant remarks. If I had to cite another one, why not? 51C, the decision, Professor Stern, your decision. Respondent tries to distinguish it. You know the facts better of that case based on the fact that there may have been attribution problems. But if you look at the holding, it's consistent with all the case law. Paragraph at page 35, what you rely on is to say definitely it's the Supreme Court decision eliminated all prospects that the claimants could obtain redress from the Egyptian state. Then paragraph 119 cites Schroer to say that this domestic dispute antedated the international dispute and ultimately led towards it. And more, I would say even more material and not specific to the question of contract, international claim, is paragraph 121, which is basically what we've been saying, the reality on the ground, good faith, fairness. Indeed, as set forth by the claimant's legal expert, there is a clear trend of cases requiring an attempt to seek redress in domestic courts before bringing a claim for violations of BIT standards, irrespective of any obligation to exhaust local remedies. Although it agrees with the respondent that there is no requirement for a mandatory pretrial before the local courts, this consideration reinforces the tribunal in its conclusion that the dispute only crystallized after 22nd May 2003, when the Ismaili court rendered its judgment. In any event, again, the case law is abundant in our favor. That's why I would in turn suggest why a respondent did not wish to insist in discussing them. And in the case at hand, each case is different. It is even more so application of these principles warranted. Why? Because each time we won before the Supreme Court. We won. So if you go back to tab 38, C33, you don't need to. You have the Supreme Court decision on due process. We won. And what did the Slovak Republic do? Exhibit C34, it nevertheless ignored it and granted it again to someone else. Then May 2011, tab 40, C36, on substance, we won. And that Supreme Court decision dates May 18, 2011. So it was rendered after the period by which we could no longer bring. So it is rendered during the permissible time frame. And this decision itself, had it been complied with, would have put an end to the agony we were facing. But the Slovak Republic, again, granted that to, and disregarded the Supreme Court decision and granted it to someone else. Until we got out of the hamster wheel I mentioned, upon receiving ultimate rejection by the MMO's decision of August 1st, 2012. It is then, and only then, with the August 1, 2012 decision, in fact, that the dispute arose and crystallized, because had it been complied again, we would have obtained our mining rights. So our position, rationa temporis, is in conformity with the clear language of the BIT and international law. It is in conformity with the principle of good faith and the reality on the ground. And if you don't want to apply estoppel, because technically speaking, respondent didn't reply to our letter, it corresponds to the conduct and to the state of mind of respondent that the dispute was premature and should wait the decisions of the local authorities. In fact, one can add a further refinement to say that there is specific performance and then a liability, and then there is a liability, there is the question of compensation, because compensation for a legitimate taking or an unlawful taking. And if you look at the chronology, tab 50, you would see that the claim for compensation was still being considered and entertained. When we wanted to file, they say, no, why are you filing? Why are you filing this thing? Give us the 4 or 5 letters. Give us the backup to what you have, and we may settle. So technically, we could even argue that the dispute crystallized as far as compensation is concerned in 2014 and in 2012 as far as liability, strictly speaking, is concerned. Now, what the respondent is trying to do is saying that no, all this is different. You have a denial of justice claim. We don't have a denial of justice claim. It's all part of one claim that was being litigated. In fact, if we were going to split, just for academic reasons with our professors, so maybe you would find that entertaining, is that if we were to split, the fact that we got a Supreme Court decision, the second one in 2011, during the permissible area that was not complied with and completely disregarded by the mining office, by itself creates another independent international law. So either way, if you want to split it or you want to join it under the concept of the crystallization of dispute, we have jurisdiction rationa temporis. That's for rationa temporis. Now I turn to lack of standing, if you allow me. Lack of standing, respondent alleges that Belmont's shares are no longer owned by us, as they were in fact transferred to EuroGas pursuant to the sale purchase agreement dated April 2001, and that we have been simply holding these shares at the registry as a collateral. That's respondent's, I think, case. Now, that argument doesn't stand for 5 independent reasons. I'm going to submit to you 5 independent reasons. Each of them on its own is sufficient to send back home a respondent on as regards this jurisdictional defense. The first one is that I submit it is undisputed that we hold, and we have always held since 2000 when we purchased these shares, 7% shareholding in Rosman at the Slovak registry. Okay, respondent says beneficial ownership has passed. You've been holding it on paper, on more than paper actually, as a collateral. We're saying even the best case scenario of respondent is sufficient for us to prevail on this point. Why? Because if you look at it closely, the BIT does not require that the registered owner be also the beneficial owner of the shares. Okay. Now I need your particular attention to the practice of sovereign states. Sovereign states try to control sometimes the identity of the investor. The Asian treaties, the Iranian treaties, for example, even require that the investor be pre-screened, pre-approved by agency that requires the names of the beneficial owners, everybody. This is not the case. Others impose the questions of ownership and control and particular requirements that are not present in this case. And I ask you to turn to tab 52 to give you an example when you look at the agreement with the Slovak Republic. If you look at the tab with the Slovak Republic and Iran, if you look at Article 1 and 2, you would see the term investment. So it's tab 52. It says the term investments means shares, stock, other forms of equity participation in an enterprise. So you would say to me, so what? Why is he bringing our attention to this? But what is relevant is what follows. Provided that the investment is directly owned or directly controlled by an investor. They don't use the term hold. They use the term owned or directly controlled by an investor. Moreover, investor is defined. An investor is defined, if you turn the page, paragraph 3, the term investor means the following natural persons or entities that have made a cross-border investment in the territory. So they use ownership by the investor or control. Investor meaning cross-border investment. So all these sovereign states, including the Slovak Republic, if it wanted to control the identity of the investor, could have done so and put that requirement in. Let's look at what it did instead, if you turn to tab 53. Tab 53 is a copy of the BIT, Article 1, D. It says, this is now as broad as it gets. It says the term investment means any kind of asset. Does it say owned? It says the same word that is being thrown at us by respondent. It says held. Held or invested. So it means invested could be different than held. Either it adds directly or indirectly by an investor of the contracting state. You say, okay, maybe the controlled investor by putting a notion that he needs to make the investment cross-border, but let's look down. The term investor means a natural person possessing the citizenship, or the next sentence, any corporation, partnership, venture, organization, association, or enterprise without any requirement. So based on the plain language, ordinary language, plain language, broad language of the treaty, the treaty practices of other states, the Slovak Republic, when they wish to impose restrictions, you would see that in this BIT, the Slovak Republic and Canada could not give the slightest care whether the person holding it held it directly, indirectly, made an investment, had any participation, had any control, had anything to do with that. And there is nothing wrong with that. There is nothing wrong with that. There is nothing wrong with that. An investor can set up his investment or hold the shares as it wishes. There is a subject, of course, to the Phoenix, Sabafakis, Cementonia, all these awards saying, listen, it's nasty, however, to change your corporate structure, your legal structure for purposes to gain jurisdiction once the dispute has arisen. But here it says holding holding directly, indirectly by an investor without any conditions, and it is not contested, and in fact it is respondent's case, that we have been holding it throughout out the registry. And moreover, in fact, even on the best case scenario respondent, they admit that we're not even acting as a puppet. Even puppet you can here. But they say we still have a collateral interest in it. So that's why, in fact, I'm surprised that I do not see the strictest analysis of respondent's position under international law based on the treaty. Nothing. As if I turn a blind eye on the treaty, I don't want to hear, I don't want to speak. But that's not what the Slovak Republic signed. Now, what does respondent rely on when it alleges that the holding is not enough? Again, no analysis under the BIT, strictly nothing. It relies merely on two legal authorities. Two legal authorities. And I would say, under case law, when there is a similar language, the majority, the vast majority, there are one or two crazy decisions out there that required shareholding and control, meaning actual control. Unanimously, they never looked at the beneficial ownership. They said legal ownership is sufficient. What do they rely on? Even when the clause didn't provide holding, even when they said ownership. What do they rely on? Two authorities. You have the first at tab 54. And was rehashed today at the opening statement. Mr. Biderman, 1989. I mean, if you stop there, you would say it's the age of stone of investment arbitration. You open it, you discuss World War I, World War II, brokers, insurance, inheritance. It has strictly no relevance whatsoever in relation to investment dispute. And it could not have, because that matter was not relevant at the time. Strictly nothing. And then the most relevant thing that doesn't even come close to materiality for this, it discusses the Iran-US Claims Tribunal, that you have some shares that were owned by Iranian company, but the beneficial owner was American. They were trying to exercise jurisdiction. There was no BIT clauses. It's completely hors sujet. And then what does the other decision? It's Occidental versus Ecuador. You have it at tab 55. Annulment decision. Now, that annulment decision is inopposite. Its reasoning is flawed, and in any event, clearly distinguishable from the facts and the legal terms involved in this case. So this is the two they have. Let's look at tab 54. It's not inopposite because you don't have a doctrine of precedent that is binding on you, but more importantly, it's an isolated decision, and it has no support. Now, before I discuss that, even if it was binding, it was substantiated that it is factually and legally has nothing to do with our case. I want to look at what the decision cites in support. Tab 55. Tab 55, it's at page 70. And actually, this was cited in the opening statement, paragraph 259. In cases where legal title is split between a nominee and a beneficial owner, international law is uncontroversial. 2 points. As respectful arbitrator Stern has stated in her dissent, the dominant position in international law grants standing and relief to the owner of the beneficial interest, not to the nominee. First, it says uncontroversial, then it says dominant position. So uncontroversial, dominant position, I don't see that the same thing. And then what does it cite? It cites Professor Stern's dissent as a backup of all this being uncontroversial. Now, we love Professor Stern. She was with you, Professor Mayer, on my juris thesis. But it's not merely enough to say Professor Stern said something and it's uncontroversial in international law. Look, what else does it have? It cites articles. Articles of whom? articles at paragraph, in a footnote, it cites articles in the footnote, 192, Mr. Vicuna, and when you read it, it's 2000, it says changing approaches to the nationality of claims in the context of diplomatic protection. Okay, what does that have to do with BIT? It's in the exit review, okay? It's diplomatic protection. Then on its face, look what it says. In claims to property beneficial owned by one person, the nominee title to which is invested in another person of different nationality, it was usually the nationality of the former that prevailed for purposes of the claims. It said it was usually the nationality of the beneficial owner. Then if you read the article, it goes on and calls for more flexibility, in fact. So, and then what does it cite? The Iranian Claims Tribunal that are completely relevant to the BIT. And that's the article. So it has the Professor Stern's dissent, then it has articles in the footnote. And look what's the article, the only article that it cites in the full text. Guess who? 260. It's Mr. Berderman when he was an assistant to in the Iran-US Claims Tribunal in the non-hors-sujet article that I wrote. That's the supporting evidence. That's the supporting evidence. Of course, it goes on afterwards, once it decides on this issue, to raise other articles in passing relating not really to this. If you look at paragraph 274, it's Impreglio versus Pakistan. It's not even relied on by respondent. Why? Because it's an Italian company that created a legal personality joint venture under the laws of Switzerland, in which it held majority participation. Impreglio then acted as the only signatory of the contract on behalf of the joint venture and was claiming money for others. So that has nothing to do. That's why a respondent is not relying on it. So basically, we're left with Professor Stern's dissent and the Occidental, the articles that are completely relevant, and one footnote that supports, in fact, our position. Then Occidental decision, what is striking also when you hear respondent relying on it, it's because it doesn't have the same terms in the BIT. If you look at the Ecuador US, it doesn't use the term hold. It terms to use ownership, okay? And finally, the Occidental decision bears no, at least on its face, I apologize, Professor Stern, you know the case much better than us, but when I look at what the only thing I have, and the only thing the arbitrators have, and the only thing the auditors should have, because then that would create a significant issue, because that's the only authority relied on by respondent, which authority relies on Professor Stern's decision. On its face, the decision, the case is distinguishable not only because the BIT contains a different language, but if you look at tab 55, page 55, should be page 135, I think. Page tab 55. It should be the last page. It's a decision, paragraph 590. It says, the committee partially annuls the award to the extent that the tribunal assumed jurisdiction with regard to the investment now, use the now, beneficially owned by the Chinese investors, okay? And then, if you look at Professor Stern's opinion, at paragraph 38, I believe, it says, it is undisputed that Andes, following the implementation of the farm-out agreement and the subsequent sale, interest has become and still is the owner of 40%. Okay? And in this case, on its face, it's not the case. In the farm-out agreement, as Professor Stern goes on to dissent, the transfer of everything of the beneficial ownership was immediate. There was not a closure date. It was immediate. And moreover, at the time of the arbitration, at the time of the decision, there was still a beneficial ownership. Here, the company was dissolved, went bankrupt. The respondent best case scenario doesn't say that there was a transfer by the date of the agreement. So, however you look at this, there is no support. The clear language of the treaty says hold. The case law says hold. The practice of the governments shows that that there are mechanisms that they effectively use when they want to control who is beneficial or legal owner, or they want the owner to have some degree of control. But here, it's not the case, and you're left with the language plain and ordinary of the treaty. Now, the analysis of the parties, second, that was my first argument in defense. I have four more that are independent on the question of standing of Belmont. The analysis of the parties' position over time, let alone during this arbitration, demonstrates, confirms that the sale was never completed, that 2000. I will submit to you as a third ground that it could not have been even possible at the closure date, legally speaking, because the company was dissolved. But here, factually, I wanted to submit to you that it is clear that the transaction was never completed. And before I walk you through the correspondence, I want to make a few general remarks. Is that it is common ground that the documents that are relevant to appreciate this question are poorly drafted. I mean, there's a common position on that. Even their expert on British common law says that. It is also undisputed, at least undisputable, that there are few amendments to that 2001 agreement. And I'll walk you through those. There is also undisputable that there is a truckload of statements, correspondence, declarations, even notices of lawyers in relation to this question. So you can't just look at one piece of document to decide and put it on a screen and say, they said this, now they said this. You have to say what was said before, what was said after, what was said below that paragraph, what was said above that paragraph. And also you need to also construe the situation where is those statements made? By whom? Is it a lawyer? Is it before the prosecutor? Is it in relation to a question of the share purchase agreement, or it's in relation to a secondary question? If it's Mr. Robol that does it, I mean, I don't understand. Respondent says I apologize, Mr. Robol. Basic respondent says Mr. Robol is a crook, then relies on its statements against us. So we have to look in time, the forum, the author of these correspondences before reaching a conclusion. Then you need to also understand there are some terms, in addition to the poor drafting that are used, that are loose in the correspondence. There's collateral. I mean, collateral, security. Could mean a lot of things. What else can I say on this issue is that what is also relevant is the position of the parties who are today in this arbitration. And if you even respondent says EuroGas 2, it's EuroGas 2, it's not EuroGas 1, you're still left with Mr. Robol as a signatory of these agreements, which confirm with Mr. Belmont, the other signatory of this agreement, that there was no transfer, that today there is no transfer, that it was never closed. So you have a meeting of the minds of the drafters of those agreements and correspondence. Why do I say all this? Is to invite you to look at this, also to address the questions of burden of proof. We have legal title at the registry. We claim that this is enough, that we have full beneficial and legal ownership today. The other party to the agreement relied on by respondent is here and does not claim to the contrary and supports our position. So the burden of proof is not only on respondent, but the threshold is one of fraud. Fraud. That means they have to show that my client's representative, Mr. Agiagos, is engaged in collusion with EuroGas. Now let's look at these documents very briefly. You have at tab 27, the SPA. It dates from April 17, 2001. I invite you to look at Article 6. Article 6, I can accept that it is, some of all the correspondences are not clear. But at least Article 6 is as clear as it can get. It says Article 6, closing. Then it says closure. Within 30 days of the date of the approval by the Canadian Venture Exchange of the transactions, the vendor shall deliver in trust to the solicitor for Rosman any and all transfer documentation necessary for the transfer of the shares to the purchaser against payment of the purchased shares and 100,000. The terms of the trust are then that the ownership of the shares will not pass to the purchaser. No instructions to proceed with the transfer will be given in the Slovak registry. Next page, unless and until 125% of its initial investment equal to Canadian $3 million it benefits the seller. So it is clear. It is clear. For title to pass, you need these conditions to be met. Now, the expert then engages. That's why there is no need for rebuttal. It picks and chooses correspondence, doesn't take into consideration the intention of the drafters that are here, does not take into consideration the fact that there is no claim by anyone except the Slovak Republic that EuroGas 1 or 2 may have had any interest remaining in these shares. And then goes on to say, yes, closure is required, but that wouldn't make sense. It would be abusive, because then if Belmont does that, where does that leave? I mean, that's not a problem. There are remedies under law. If the beneficiary of that right thought that the other party was abusing it, it would have a recourse. There is no recourse. And there is no problem, Professor Mayer, in Belmont selling the shares. Does it provide that we have to restitute the shares if the transaction is not complete? Where does it say that? Assuming there was such a right, it has to be exercised. But that, why is that relevant? If we signed, if I want to buy your property, and we do an act together, a compromis, private compromis, and I give you $20,000, I'm not able to close. Why can't you, in the meantime, even sell the $20,000? The $20,000, nothing percent. You can sell. You can sell whatever you want. Then, if you want to go through the transaction, if I have a right to return it, that's another thing. Here, there is no right of return. There is no restriction on what we can do with what we received. So on its face, the agreement is clear, and there is a common ground that Belmont first never received $100,000 in full, and Mr. Agiagos will let you explain why. Belmont never placed the shares in trust. Belmont never received the 3 million Canadian dollars under the above agreement. There was no closure. EuroGas, nor no one claims ownership, nor does Mr. Robal believe that he's entitled thereto. The shares have never transferred to EuroGas. EuroGas never requested the transfer of the shares, nor did Mr. Robal. So these facts alone are sufficient for you to reject. Yes?
Factually, the cash received by Belmont when it sold the shares of EuroGas, what became of that cash? Did they give it back?
No.
Kept it? Or what?
To the best of our knowledge, subject to confirmation, it was not restituted. But so what? That's what I was trying to address. So what? Does the agreement allow oblige Belmont to restitute it? Is someone claiming that amount? Under what ground does the defaulting party have to, which has delayed the closure, it cannot make.
I understood the
Yeah,
argument.
okay,
I was,
good.
it
Okay,
was
good.
just factual.
Good, good. And the counter, the alternative argument also to that is that that's a position that maybe whoever, assuming has a right to claim, which is not provided under law, it's not provided everything under the contract, has, still doesn't overcome the finding that we have title. It's a question of how much that we would have to reimburse eventually EuroGas, which is not at all relevant for purposes of jurisdiction. Now, I propose to walk you through the documents. When I said, let's look at the documents, tab 58, these are the documents, tab 58, tab 59, that are relied on heavily by respondent. These are consolidated financial statements. You're dealing with auditors. It's not the place to provide a history and detailed analysis of the SPA. And you have to read it in the context of what I read to you in terms of the content of the SPA. And it says, in any event, that the company holds, if you look at tab 58, holds the Rosamond shares pending settlement of the amount of guarantee shares to be issued. Okay, it holds it pending completion. And then tab 59, it similarly says pending realization of the terms. So every document you look at, the facts today, at the time, is that the thing was not completed. Now, maybe it's not the language that a lawyer would use, but the constantly, there is a reference to an agreement that needs to be completed. Now, on the ground, what was happening, if you look at tab 60, C299, C330, 303, you would see that Belmont was continuing capital injections in the company. 2001, 2003, 2003, 2003, 2004, it's C299 to C303, it's in tab 60. Plus, we have the witness statement, tab 29, that in 2004, Mr. Agiagos, moreover, was on the ground. So in practice, you have to consider also what was going on the ground, that we were continuing injecting money. So that reality, that we're participating physically in the gatherings, and we were injecting money, is incompatible with us just holding the title as a nominee. Now let's go to tab 60. You would see there's a letter of October 30th to 2003 of Belmont that confirms that there was a breach by EuroGas of the SPA, and says for the breach, on the assumption that EuroGas wishes and can continue, is that, okay, but every $10,000 we put, we get back 1% of the shares. We get back 1% of the shares, assuming the transaction obviously closes, because it has not closed, okay? Then the next tab, it's an amendment dated November 2000. It's Exhibit 298. November 8, 2003. It's an amendment that shows that Belmont went a step further and reserved the option to get back up to 57% for each $10,000 that it pays. But to get back within the context of the SPA, assuming that the transaction closes, right, and that the other party can close it. And then you have tab 62, C296, amendment of SPA, dated April 27, 2004. It says the parties agreed to complete the purchase of the 57%. So you have to complete something. That means it's not done yet. subject to payments. And moreover, at the time, EuroGas was not able to meet the conditions. And if you look at tab 63, we said we will share, if you do not, we will sell the 57% interest in Roseman if you're not able to comply. Then tab 64, there's a notice of default. Then tab 65, we have EuroGas and Mr. Robal still claiming, pushing, thinking that he can still close the deal, complete the deal, and enters into an amendment, C297, for issuance of further shares, so to allow Belmont to reach closure amount, but which was ultimately not reached. So if you pause there, you would see that both parties even agreed at that time that they could not complete, have not closed, have not completed the sale. Now, if Mr. Belmont wants to offer the shares to a buyer, that's his problem. But even that, I think for it to happen, has to be put into context of Mr. Robal saying to anybody, or that anybody, that third party, requiring proof that the transaction has closed. So it's wishful thinking on the behalf of Robal, saying, okay, I want to propose those sales. It's subject to completion, having him title. Otherwise, it's impossible. Any event, you have moved to tab 66, C343 is the press release. Belmont unequivocally confirmed that Belmont owns 50% share of the Roseman, which holds the interest in the deposit. You have tab 67 and 68, C344 and C345. Belmont again declared in August 2008 and June 2011 that it has officially requested an acceleration of the return of the talc deposit. It has filed these requests on behalf of Roseman, which owns a company which EuroGas owns 33% and has an agreement to acquire 50% shares. Then tab 69, May 1, 2008. Here you have EuroGas that no longer claims beneficial ownership, but only a right, again wishful thinking, to purchase the 57% shares if it were to pay $1 million more, tab 70. Yes.
Thank you. But all these documents refer to EuroGas Inc.
Yes.
But at that time, EuroGas 2 was already existing, no?
Yes, but you know, I'm just putting to you all the documents
No,
that
I'm
are
trying
in
to
writing.
understand, that's all.
This is, I would say, my colleagues' problems that I will explain. I'm just telling you because a respondent is pick and choosing on the question of SP on some documents to show that for EuroGas it has closed. I will get to your question, Professor Stern, when I address my third jurisdictional defense to this.
No, because you said at the beginning, if I listen
Yes.
carefully, that EuroGas Inc. could not transfer anything to you because they were dissolved.
Yes.
Like you couldn't make the SPA.
Yes. The second jurisdictional
So-
defense I have here is that if you look at the correspondence that I'm walking you through, you would see factually that there is an agreement and there is proof that the transaction never closed, assuming it could close. Then I'll move to the agreement. I'm just running through the declarations to say that nowhere it is stated that it was done. It's firm. It's always subject to completion. That's what I'm telling you. And the conclusion of that is that if you look at all these correspondence, it is clear that Belmont today, contrary to Occidental case, is both beneficial and legal owner of the claims. Nobody is claiming those otherwise except the Slovak Republic. Nobody. Not the author, not the company, not the trustee, nobody. Now the third defense that may perhaps allow me to clarify this issue for Professor Stern, is that respondent did not have the authority nor the capacity to close the transaction. Legally speaking, EuroGas could not have held beneficial ownership at any point in time, legally speaking. Why? If you turn back to the SPA at tab 57, you would see at Article 6, it says closing. It says closing within 30 days of the date of approval by the Canadian Venture Exchange of the transactions described in this agreement. So that's a condition precedent. And if you look at Article 2.4, actually, representations, the purchaser represents and warrants to the vendor that now and at the closing, it has the full authority to enter into this agreement. Now, and in tab 7, you have the respondent's Canadian law expert that agrees that closure can occur only if you get the venture authorization of stock exchange. And there are two certainties now. Tab 71 R217. The first certainty is that this SPA was approved by the General Assembly of Belmont only on July 16, 2011. Okay. The second certainty, and there is no dispute on this, it's tab 71 R217. Second page that shows that on July 18th, 2001, it's the Canadian Venture Exchange accepted the purchase agreement, approved it. So there is a common agreement that the approval was obtained in July 18th, okay? And there is an agreement that you can only close and meet the conditions. You can only close as per Article 6 on July 18th, 2001. Now this is fatal to respondent's case and again proves the inconsistency and frivolous nature of its defenses. Why? You have the answer in tab 72. Tab 72 is that on July 11th, 2001, the company was dissolved. So EuroGas could not have closed. Previously, we saw that it did not meet the conditions and the transactions were completed. Here we have scientific close, and it's not respondent who's champion of Utah law and public policy and corporate law that can contradict me. EuroGas did not have the capacity. It breached the covenant at Article 4 that it could close, and the shareholders' agreement at Belmont was granted in ignorance of that representation. In any event, forget about the shareholders. The Article 6 said you can only close if you get the stock exchange agreement, and the stock exchange agreement was provided only on July 18th. So I'm afraid that's done, finished. We have to close this question that has been costly to Belmont. We don't need to show that we have anything more than holding. Assuming we do, factually the transaction was not completed. Nobody's claiming on EuroGas or Belmont side, or nobody at all is claiming any title to the beneficial ownership. And now we see that that SPA could not have been solved. So now maybe there are questions. So what do? We keep the money we received? Yes, we're happy to keep the money. Where does it say that we couldn't keep the money? Maybe we have damages again as well to those that declared that they had the capacity. The contract doesn't say we have to restitute the amount. Law doesn't say we have to restitute the amount. There is also, by the way, statute of limitations to whomever wants to claim that we have to restitute the amount. But that's not it. We have a fourth defense and a fifth defense. I will be very short on those. Maybe before I get to the fourth, I would like to draw your attention to tab 76. Tab 76 is what EuroGas even said. Maybe that will help maybe Professor Stern. Tab 76, bankruptcy, before the bankruptcy, what a EuroGas representative said, and he said to the question, now you owe another 12 million if they're willing to take it, or they want 1.6 million Canadian dollars, correct? Do you have the ability to pay? It's a reference to the SPA. He says, right now, no. And it says, it is true that your testimony was that you had 4 to 6 weeks to pay, that our, or the talc deposit will be lost. They're a very significant possibility, yes, okay. In addition, you have an ongoing royalty. So there was a common ground also that the issue was discussed, outstanding amounts acknowledged to be done for completion before the bankruptcy court, including by EuroGas 1. In other words, that the sale was not completed, assuming even it had the legal capacity, which it did it to close. Now, I didn't walk you through the winding up. Once a company is dissolved, they cannot do anything but wind up, because here I pay reference to respondents' position on this issue, which we're happy to follow as a alternative defense to the first two that I presented. Now, fourth defense, a very independent defense, is that assuming Belmont held only shares as a collateral at one point of time, it ultimately exercised the collateral at it legitimately officially warned EuroGas that it would for breach of the SPA and for inability of EuroGas to pay. It's at tabs 64 and 66. So be it under law because of the insolvency or because of the inability to close, we exercise our collateral. We don't need to go to the court to exercise. We kept it for this very purpose. And those who are not happy or contesting that could have gone, and nobody has gone. So exercise that collateral, assuming that the SPA could have been closed, which we see now could not have legal, assuming that payment was made for the beneficial ownership to pass, and that we only held it for a collateral, ultimately we exercise that collateral. Fifth and last independent defense is that assume we hold it for a collateral. And now you ask, go back to tab 53. We don't want to insist on that. It's just, again, for the sake of completeness, we go back to the BIT. It says at Article 1, the term investment means any kind of asset held or invested either directly or indirectly. Then 1, movable and immovable property and any related property rights such as mortgages, liens, pledges. I mean, if you have a collateral, holding is enough, but even if we had a collateral, without the holding, it would be enough to exercise jurisdiction based on that provisions. And if you go back to tab 52, you would see, if you look at the Iran treaty, that at Article 1, I would say 1, and then it goes on to say, when it discusses loans and debt securities, Slovakia, when it wants, like other sovereign states, puts a limit to jurisdiction exercised by those that hold a security that says, okay, but it has to be only in relation to loans and debt securities with the original maturity of less than 3 years, a loan or debt security issued by a financial institution, and the extension of credit in connection with a commercial transaction such as trading finance. So I think however you look at it, based on the pure language of the treaty, based on the facts, based on Utah law, based on the concept of holding a collateral which we exercised, or the mere holding as a collateral, we have jurisdiction.
What do you mean exactly, we exercise the collateral? Can you explain that?
When we exercise the collateral, it means that when we wrote to the in the public, and we wrote as a shareholder, beneficial owner, and legal owner to the government seeking redress, at that time there was no prospects of EuroGas being financially or legally capable of completing the transaction. As we held the shares, this is our alternative claim, huh? I just want you to make sure. We kept title. We kept title. The transaction didn't provide, that's why I said these terms, security, collateral, mean many different things. You have to look at the contract. It's not that we would then sell the shares and put it in auction and get what amount is outstanding so for the shortfall to be completed. We keep the shares and we keep the money. Why not? There is no provision to the contrary. Nobody is claiming the contrary. Worst case scenario, if somebody dares EuroGas robot come and say restitute the money, we say why? Maybe we are entitled even to damages against you. Or worst case scenario, we restitute the money. But that's not an issue before this tribunal. So thank you. To summarize, I come back to my conclusion that it's a scientific on liability for many reasons. In terms of procedural impropriety, we gave you the reasons that we think we were the victims, not the offender. And finally, in terms of jurisdictional objections, their defenses are inconsistent, frivolous, in violation of the law for the many reasons I set out. I thank you for your attention.
Thank you very much. So now we turn to Ms. Burton for the jurisdictional objections concerning EuroGas.
Mr. Chairman, before we do, could we just have an update on the time that each party's used so far? Thank you.
Yes, so I gave your colleague your count of time. I believe you used 1 hour and 38 minutes, if I remember correctly.